All right. Hello, everyone, and welcome to our workshop entitled Estate Planning Secrets to Protect Your Family. We're so excited that you've decided to join us today, and we can't wait to provide you with exclusive information and resources that will give you a deeper understanding of us and our services. My name is Emily, and I am the Marketing Director for Clinkscale's Elder Law Practice. We're actually celebrating our 40 years in Hayes this year with our main office located here in town, and then our other office in Wichita. And we do serve clients and families throughout the entire state of Kansas. I would like to invite you all to type any questions that you may have in the chat box that's located at the bottom of your screen. And then you can do that throughout the entire presentation. And at the end of the workshop, we will address any of those questions or concerns that you might have. So without any further ado, I would like to hand it over to our attorney and managing partner, Jenny Walters, to get us started.
Okay, thanks, Emily. I can see some of the people on. It's always nice when these are on Zoom and some people choose to share their video because it feels like I'm talking to real people and not just the screen. So nice to see everybody. So today, like Emily said, we're going to cover some estate planning secrets to protect your family. And what I want you to discover is ways to avoid the government controlling your property, your decisions, and your affairs. Avoid the biggest estate planning mistakes that we see, how to choose your agents that will follow your wishes, and we're also going to cover how to pay for care, specifically like long-term care, home care as we get older. This is for you if you do not have an estate plan or an estate plan that's out of date, if you're not sure what your estate plan does or how it works or whether it will even work, if you want to preserve and protect your property and income for your spouse and your family, if you want to pass on or protect a business, if you're concerned about paying for long-term care, and if you just want to be sure your wishes are followed. So imagine if you could wave a magic wand, what would you want? Would you want to stay at home as you age? Would you want to have a plan that ensures and empowers someone to carry out your wishes? Have a plan that you understand and know it will work? Know how to pay for care? And have the peace of mind that you won't lose everything to long-term care costs and that your legacy goals are protected. I imagine people on here have an idea of how much care costs these days. Around here, it's getting up to like $7,000. Can be even more if you get into more of the cities. I just want to share a little bit from Tad. When my wife was diagnosed with Alzheimer's, I tried to care for her myself. My son, a doctor, told me I had to get help or we would end up with 2 sick people. My banker recommended Clinkscales. Clinkscales helped me care for myself and my wife. They helped monitor my care and my wife's care. If I ever had a question, I just had to pick up the phone. Let me talk about a little bit about who we are. We're an elder law firm. There are 3 attorneys, and we'll talk about some of the other staff members also. We focus on helping families preserve and protect their dignity, their health, their finances, and their legacy. We have a practice throughout Kansas. We have offices in Wichita and Hayes. I'm in the Hayes office. The firm began in 1983 by Randy Clinkscales, and I'll talk a little bit about how that has evolved. And we have a unique and holistic approach, which I'll get into, in that we're more than just a firm that does documents and sends people on their way. If people are facing chronic illnesses, trying to pay for care, protect assets, we try to help them along the way with documents, as well as figuring out how to pay for care, where the appropriate placement is, how to stay at home, those kinds of things. So, and related to that, what makes us unique is that we have care coordinators in our office. Right now, we have 2 care coordinators that are registered nurses. We have one that is a social worker. They all have backgrounds in nursing home care, whether that's in actual nursing or social work experience in the nursing home, and they all have dementia training. And right now, our care coordinators are Jessica Ritter and Jill Wexler and Risa Legleiter. And their role is to, again, help people figure out how to stay at home, what services they might need, if they can't stay at home, what the next steps are, because there's some steps in between home and long-term care, and just how to support families and the people who might have a diagnosis of dementia get the best care possible. A little bit about myself. one of the attorneys here. I've been here since 2009, got kind of lucky and landed here out of law school. I focus on helping people with aging and chronic care issues, kind of like I work in as a team with our care coordinators and work with people to protect their assets from long-term care costs. I do a lot of Medicaid planning as well as the estate planning that we're going to talk about today. I'm a member of the National Academy of Elder Law Attorneys. This year I'm the president, and I'm a member of the Life Care Planning Law Firm Association. This is a little background to my life. I am married, but my kids are a lot cuter, so they're on here. And we love our animals and 4-H and horses, and hopefully this calf Scarlet will be at our house this summer to maybe take to the fair. And this is Stella and Theron. And this is Randy. And I want to talk about why we're so passionate. This all began, the firm started in 1983 in Hayes, but it's been in the last 15 years or so that we've been really focused in the area that we are now. And it started with Randy and his grandma. I'm going to talk a little bit more about her later, but he switched his practice to this area that we're in now because he became her primary caregiver. And through some of the planning he was able to do, and with the help of a care coordinator, helped her stay independent, helped her stay out of the nursing home. She was able to stay in assisted living for a very long time, which was what she wanted. And he was able to have a plan. And he says that the journey can be and was wonderful because he had a plan. And you need a plan to adequately and effectively take care of yourself, your spouse, and your family. So I'm going to start in with number 1, which is how to keep the government from controlling your property, your decisions, your affairs, and your retirement planning. Without a plan, the government and the courts make decisions for you. And I'll get into why that is. No one has the automatic right to help you or follow your wishes, not your spouse, not your kids. That is not automatic anywhere. That's got to be in your plan. You can determine who has what authority, and the documents that you need are not just forms. They're pretty specific. I want to give an example of not having a plan. So Mr. and Mrs. Wright attended a workshop. They had no estate plan, no powers of attorney. They were a farming family. They had some property in joint tenancy, or some of it just in Mr. Wright's name, had equipment, livestock, typical farming family. Went home to think about it. Mr. Wright had a stroke, lost capacity, and eventually passed away. He didn't have a power of attorney and didn't have a plan. The joint property that was with his wife went to her because it was joint, but the other property had to go through probate. One half went to his wife, but the other one half went to the kids because that's what the law says. As you can imagine, that created some family difficulty. People had to transfer property back to Mrs. Wright, and there were tax consequences and hurt feelings. However, her next step was to set up an irrevocable trust to protect the land, also some really good powers of attorney. So she had children in charge that she could trust. She was later involved in an accident, but the land was in the irrevocable trust and was protected, and we got her wishes protected. And her comment was, we should have done something when we came in. Our delay cost us over $40,000 and created a lot of stress for me and my children. So if you're incapacitated, again, no one has the right to act for you. If you do not have someone named to act for you in a power of attorney or as a trustee, the court will appoint somebody, whether that's for healthcare decisions, which is a guardianship, or financial decisions, which is a conservatorship. It's paid for by your own money to get this stuff in place. Sometimes it requires bonds, and it does put some limitations on the individual that's named when they're trying to make decisions and do some planning for you because you have that court oversight involved. If you die without a will or a trust, then you land in what's called intestate proceedings, and the law dictates where your property goes because you don't have a document that says where it's supposed to go, so it defaults to what the law says. And in that example I gave earlier, the spouse could lose half the property, You end up with a conservatorship for your minor children that you don't have control of who is named for them and for their financial decisions, and a guardianship for minor children if there's no surviving parents to take care of them, more of their health decisions and who takes care of them. So the essential documents to avoid all this are a financial power of attorney, a healthcare power of attorney, a living will, and either a will or a trust. And I'll get into a little more about what each of those documents means. So durable power of attorney, sometimes people think of it as a financial power of attorney, is where you name an agent and preferably a backup, which are the people that you have named to take care of financial decisions and property management for you if you no longer have the ability to do that, whether it's you're actually incapacitated and can't make decisions, or just physically you can't get around very well and you need someone's help. Within that document, you can also name who is your guardian and conservator, so that if you really lose capacity and start making some poor decisions, if you need the court to put somebody in charge of everything for you, you've already named who that person is. Another really important thing with powers of attorney is that the quality of the document really depends on what powers are in that document. There are 15 optional powers in Kansas law, and if you don't have those powers specifically in your document, your agent can't do them. So, for example, that's dealing with your home, that's making gifts, that's making trusts, that's disclaiming an inheritance or changing beneficiaries. And for our type of planning, especially with Medicaid planning, those powers can become really important. And if we run into somebody that can't sign a new document, and let's say we want to do a gift plan and we want to set up a trust, if that power is not in the power of attorney, we're stuck because we're not going to be able to go to court and get permission to do some of the things we can do. On the healthcare side, we call these advanced care directives. The first of all is the living will. Can kind of be confusing when you have living will versus last will and testament. A living will is a document that gives your end of life preferences and your decisions, so that if you, what ours generally says is if you have two physicians that say that you have some sort of terminal condition that you're going to die from, you don't want anything that's going to artificially prolong that dying process. You don't want to be on a respirator, a ventilator, tube feeding, antibiotics, basically want to be made comfortable. And what that living will does is gives direction for the person on the next document, your healthcare power of attorney. That's the person you have named to make healthcare decisions for you. And that living will tells your healthcare power of attorney agent and your doctor what kinds of decisions you want made for yourself if you're in that end of life situation. Some other documents I want to mention that have to do with health is a do not resuscitate. That is something that's done with your doctor if it's something that's appropriate to have in place. And then there's also a HIPAA authorization, and that's something we do to make sure that you may have your healthcare agent as the person named that you want to make decisions, but maybe you want the rest of your family to be able to get information, to see how you're doing, to ask questions, and that's where that HIPAA authorization comes in. So what do you need to do? First step is schedule a strategy session as soon as possible, because you want to act before capacity is an issue. Nobody wants to think about that, but it happens. And it's better to just get that stuff in place so you know you're covered. You want to express your goals in your legal documents, and those documents will empower your agents and your caregivers to carry out those goals and to just not give up, to get it done because there's solutions. Number two, utilizing an effective estate plan. So we've talked a little about the documents to give people the power to take care of you and to accomplish your goals. We're going to get a little more in depth in the estate planning document, like the wills and trusts, and what those can actually do. And so those are going to be in writing. They're not generic. They're not just templates. They're unique to your goals, your family, and your situation. Sometimes they can reduce or eliminate taxes. Your trustees, executors, and agents are equipped with the knowledge, the instructions, and the ability to follow through with your wishes and your goals to avoid the court and fighting, like in probate. And you got to make sure your assets are properly funded through your plan, which means, well, we'll get into that. It means that everything's got to be set up correctly. It's not just as simple as signing the document. Let's go through an example. I think it helps to kind of visualize this. So Mr. and Mrs. Jackson, they're 66 and 69. Mr. Jackson is still working. Mrs. Jackson is retired. They own a home. They have a family business. Their investments and retirement funds are about $400,000. They have them pay on death to each other and then their kids, which is pretty common. They're relatively healthy and they have no estate plan. They have 4 children. Son Bud is married with 2 children. He works in the business and hopes to take it over. Son Mark is deceased and has a special needs child. Daughter Debbie's going through a divorce and has 1 child. And daughter Barb has been in and out of drug rehab programs, is divorced and has 2 children who live with their father. And so that's can be a realistic example of how many things can be going on with kids that we need to think about. Mr. and Mrs. Jackson want their business to stay in the family. They want to be fair to all the children and they want to avoid litigation and they want something to go to their grandkids. Also a pretty common wish for people in their family. Here's where it gets a little tricky. If they do nothing, they have no power of attorney with wishes. They have named nobody with the authority to act. So the court involvement could become necessary for that guardianship and conservatorship. Their assets could end up in probate because we didn't talk about what they did with their house or with their business. And let's say then their kids did inherit it through a probate. They could lose property because of this potential divorce issue and not protect the daughter's share who has the drug problems. And then if they have a disabled grandchild who gets money dumped in their lap, they could be kicked off their benefits or that money have to be spent on their care. And it just causes all kinds of problems. So the solution is to start off with powers of attorney with good agents and have all those powers in there, have their health desires protected, have somebody named to make healthcare decisions, put in place a revocable trust to manage their property and avoid probate. That could also protect the business for Bud and explain why, and hopefully stay out of litigation because they've set everything up correctly. They could protect Debbie's inheritance from divorce, protect their special needs grandson's share, and protect Barb's inheritance from her drug problems. So something can go to her children and not to their father. And do this all through changing those beneficiary designations to have it all go through the trust that can take care of everything. One more example, Mr. and Mrs. Augustine. They want to transition their farm to their children. They started to sell it to their children. However, they ran into tax problems, capital gains taxes, taxes if their children want to buy each other out, and just losing control of it because they're really not ready to let it go. They just thought this was the best idea at the time. Sometimes people are surprised by if they sell something large like that, the increased income affects their Medicare premiums. And so the solution was instead of sell it to their kids right now, to put it in an irrevocable trust. It's a safe place to hold it for their lifetimes. And if they want, they can still give the income to their children. But really importantly is through this irrevocable trust, when they pass away, their kids inherit it and they get a step up in tax bases, which is really important when it comes to farm ground. They also retain the right to change beneficiaries. If something unexpected happens while they're alive, they can adjust their plan and again, fix those tax consequences and they don't have that Medicare premium problem. One more example, the Jones family. They did a revocable trust after a trust seminar, which is sometimes a place to go and just get kind of a standard trust done. And just a standard power of attorney, not specific to Kansas law. They have a daughter with special needs and they have 2 children under 18, 1 adult child. They have a home, a checking account, investments held jointly. They have an investment account held jointly with one of their daughters, and they have IRAs. The problem is they haven't set anything up to go through an estate plan. It'll go, if it doesn't have beneficiaries, it's going to go through that intestate succession that we talked about. And the one account that's held jointly with the one daughter is going to go to her. So that's not really how they're wanting things to end up, but that's how they have it set up. So the solution is to fund everything through a trust to help save taxes on the IRAs to protect things for the disabled daughter. It avoids the conservatorship problem because they can name somebody in charge of that daughter's money. And instead of having that investment account held jointly with the daughter, they can run it through their trust so it gets distributed equally according to their wishes. So what do you need to do? Schedule a strategy session as soon as possible so you can get your estate planning documents in place to accomplish your goals so we don't run into the situations like the examples that I've talked about. And then I want to be real specific. You've got to fund the plan because like that one example, even if you do a trust, that's great. That's a good start. But if you don't go on the back end and make sure your house and your checking and savings and your retirement accounts and everything's set up correctly to go through that trust, it really doesn't do any good. You'll throw them into probate because you haven't funded your trust. And that's something we make sure gets done after we do those trusts. Okay, I want to move on to the next topic, ways to pay for care. I know this is more focused on estate planning. However, it does kind of tie in because what you have in your estate plan can affect how your family can pay for your care if something unexpected happens and you do need long-term care. Nobody wants to go into the nursing home. Sometimes things just happen and you need to have a plan because, like I said, it's getting upwards of $7,000 a month. And how you've set up your estate plan can make a big difference on how your care gets paid for and how assets can be protected. So it all kind of ties together. And so I want to cover to make sure that you can make the decision on how to pay for care and let you know that you don't have to go broke if you do need long-term care. There are planning options, and I want you to learn that you can use government benefits to pay for care, such as Medicare, VA, and Medicaid. Start off with an example, pretty typical example of what we see out in this area. Farming family, Mr. and Mrs. Lundgren. Mr. Lundgren has diagnosis of dementia, but he's still a very active farmer and has capacity. And understandably, he's really concerned what's going to happen years from now if he needs more care. He's concerned for his wife and his kids. So the solution is to set up one of those really strong and broad powers of attorney, like I talked about, with all those powers in it, so we can do whatever we need to do. And then put the land in an irrevocable trust. Because we're not looking at Medicaid, he doesn't need long-term care. We can pre-plan and protect the farm ground in that trust. Make sure he has really good healthcare powers of attorney and that he talks with his children about what his wishes are if he should progress and lose capacity to make those decisions for himself. And again, even though we're pre-planning, we make sure that his goals are set and guaranteed through his plan. His land is protected. He remains control. He doesn't have to give all his assets away. And we also make sure that his wife has the power she needs to take over things if she needs to, and take that pressure off of his family and give him some peace of mind. Another example, Mr. and Mrs. Johnson. They're both in their 70s. Mr. Johnson has a stroke with dementia, is in the hospital. He needs to be discharged. They've got pretty good income. They've got a home, investment, and a business worth $500,000. And we don't see a lot of this, but every once in a while we'll have people that have long-term care insurance. And this one's pretty good. It pays $200 a day for 3 years. And their concern is, how do they pay for care? What if they use up the long-term care insurance? They want to make sure that something is protected for their spouse and for the kids. So the solution was to transition Mr. Johnson to a skilled facility and make sure he's on skilled care. So Medicare will pay for that. It won't pay forever, but it'll pay for a period of time to help him rehab. And then in the meantime, make a plan for him to come home and use his long-term care insurance policy to help pay for home care, because sometimes those policies will actually cover home care as well and not just nursing home care. So the result was that his care at the skilled facility was covered. He got well enough to go home with a lot of assistance that was paid for by that policy. And by getting involved early, it did 4 things: got Medicare benefits extended, got his health improved that he needed, and he was able to return home with that policy to protect his assets. One more example, Mr. and Mrs. Schmidt, 72 and 70. They're recently retired. Mr. Schmidt has a $350,000 IRA. Mrs. Schmidt has $200,000 in investments. I'm sorry, she has a $200,000 IRA. They have investments of $300,000. They've got a house, 3 kids, and 5 grandkids. Pretty typical situation that we might see. The concern, though, is if one of them gets sick, they're worried that assets are going to be depleted and the spouse is going to be impoverished, and they want to leave money for their grandkids. And this is a really common concern that I see. If one of us gets sick, it's all going to be gone. And the solution in this case was to look at a hybrid life insurance policy with a long-term care rider. There's a lot of new products now where you can get life insurance and long-term care insurance kind of wrapped into one. And depending on your age and some things, sometimes it's a good solution. Initially, they were reluctant to do that. However, with their kids' help, they were able to explore those options and get something in place. Now, even if that's not an option, there are other tools available through Medicaid planning to protect assets for a well spouse. And this is where we get into a crisis example. We're past the window for long-term care insurance. We're past the window for an irrevocable trust. What happens now? So Mrs. Smith has Lewy bodies dementia. She's been discharged to the nursing home from the hospital, and she's paying $8,000 a month, which is not unheard of. Their assets include her husband's retirement of $300,000. They have a joint account of $60,000. He has Social Security of $1,500 and she has Social Security of $800. Again, really common scenario. One spouse needs nursing home care and they've got some assets that could be drained if nothing was done. And they were told by the nursing home that they would need to spend down all of their resources before Medicaid would help. And this is also really common for me to hear people just getting told little bits of information about how Medicaid works. They're going to take their house. They're going to take this. You're going to be left with nothing. And I'm able to explain how the rules are there to protect assets, and that's not necessarily the case. So having been told this, understandably, they were worried that Medicaid was going to put a lien on their house. She wouldn't get good care if she went on Medicaid, which is another common misconception, is that care is different if you're on Medicaid. So the solution was to use some of our Medicaid tools and documents to restructure their assets, transfer things around. We're able to qualify the wife for Medicaid and shift the assets to Mr. Smith so that he could stay at home, be able to take care of himself, and that's pretty typical Medicaid planning that we can do, so that we don't have to lose everything. So the result was he was not forced to go broke. He has enough income to care for himself, even though she's on Medicaid. There's no lien on the house. He can sell it and keep the money because of some planning we can do, because we would move the house over to him. And he can even keep his retirement, because under the Medicaid rules, the spouse that is at home, they don't have to spend their retirement account. It's protected. That's just an example of some of the little rules that are in there that we can use to protect assets. And so we monitored his wife's care through the care coordinators, advocated for her, and gave him peace of mind that she was getting taken care of and he was financially taken care of. I also want to add that sometimes the VA can be helpful. If one of them was a wartime veteran and we were looking at maybe assisted living for one of them, for a veteran, there can be up to $2,200 a month in VA pension benefits. That's just something we keep on our radar to look into if we have a veteran. My dad would have lost everything financially had it not been for Randy and his team using their expertise to to divert what Randy termed the approaching train wreck. What Randy did for our family was to create a life care plan for my mom with a goal of keeping her safe and protecting as many of their assets as he could. We used their social service expertise, legal services, and all the other services that came with this plan. It was an investment that my dad and my sisters and I shared. Had we not done it, I'm convinced my father would not have his house and the small farm he grew up on. The plan paid for itself 100 times over. If you're an individual wondering how you will one day respectfully care for your aging parents, consider checking into this law firm. What do you need to do? Again, schedule that strategy session, which we'll talk about again at the end of this. Explore all the ways to all the funding resources, Medicaid, Medicare, private assets, long-term care insurance, get in place really strong powers of attorney and the other documents that we talked about that will ensure all this planning can be done. And again, the goal is to find, get, and pay for good care without going broke. I think the last one is how to stay at home. Again, we're kind of stretching the estate planning topic, but to me, it is all kind of ties together. And because this is really people's number one goal is they just want to stay at home. It is important to keep in mind that it's not just in most places. If you get in Western Kansas, there's not a ton of options, but generally it's not just home to nursing home. There's home with more care, there's independent living, there's assisted living, there's some steps in between there to try to stay as independent as possible. This is where I want to talk a little more about Randy's grandma in his story. This is his grandma, Thelma. She was 86 years old. Her last child, which was Randy's mom, who was living with Thelma to help care for her, died unexpectedly. She was 560 miles from the nearest family member, which I think was Randy. She had health issues. With her heart, she was frail. She was depressed and giving up. She had resources of $60,000 in a home, and her goal was to just live independently and alone. The issues, though, was limited money. She needed hospice care at that time. The healthcare professionals were urging that she needed nursing home care, and she just wasn't very close to family. So the solution that Randy found, working with our first care coordinator, Marie, was to find resources in the community, and she stayed in her own home for years. After that, she was able to move to assisted living in Hayes, actually, and with advocacy that allowed her to go into that facility, and they were able to advocate to keep her there, even if the facility felt that they couldn't anymore. They got resources in place so she could stay there. And at the end, she only spent 50 days in the nursing home and died at 96. So that was a pretty good ending for her story. And the lesson was that with proper guidance, you can stay at home longer, the transition can be gradual, and having support for the caregiver, which was Randy, was critical, and to be able to stretch the resources to achieve Thelma's goals. Another example is Lane and Lisa. They came to us 5 years ago. They were both in their 70s, and Lisa has MS. Lane has scoliosis. The children lived in other states and have their own families and are too busy to help, which is not uncommon. Or what we see is there's just one kid around and it's all on them. Lisa had just transitioned to an electric wheelchair. The issue was that Lane realized he would be unable to help lift Lisa much longer. They tried to find help in the home. They didn't really know what they were doing, and they'd been through several different people, which is not uncommon with home care. They were both concerned that Lisa may need to be transitioned to a nursing home for the sake of Lane. The financial resources were not an issue, but both were overwhelmed. The solution was that our office helped find reputable caregivers. The first barrier was to convince Lane and Lisa to accept help, which is common. Once we got over that, we continued to monitor them. We got Lane into therapy and created some time off and days off for Lane, and we directed them on how to modify their home and their lives for accessibility issues. And the result is today Lisa's still at home, though the MS has progressed. Lane's back has continued to deteriorate. However, they're both at peace. We have an ever-evolving plan to keep them at home, which is, like I mentioned, our services are unique in that we want to stick with people, hopefully for their lifetimes, to change the plan as things progress if we're in a situation like this where we have a chronic health issue that's going to change as the years go. My husband had Parkinson's. You helped me keep him at home as long as possible. You showed me how to be a better caregiver. I could not have figured out how to pay for care with Medicaid and Medicare on my own. That's from Sherry. What do you need to do? If you're facing an aging or chronic illness issue, meet with us for a strategy session. Don't wait. The longer you wait, the greater the crisis and the more limited the options. We like to get involved earlier versus when things are kind of on fire. And don't give up. There are solutions. From Pat, my husband needed nursing home care. You guided me through the process. Your care coordinators made sure my husband was getting good care. I highly recommend you because you are always there for your clients and will guide them through everything that goes on, things we never expected to go through. So far you've discovered there's certain documents that empower others to act for you and to protect and preserve your wishes, whether that's health, financial, or your legacy when you're gone. That planning allows you to pay for care without losing everything through some of the Medicaid planning we can do, or even the pre-planning to protect assets. And that can be done without putting a financial burden on your children or other family members. And there are ways to stay at home longer if you have the guidance to get that accomplished. I hope you get this one thing. For most of us, at some point, someone will be trying to carry out our wishes. Even though that's hard to think about, the people that we meet with are generally the families that are trying to carry out their loved ones' wishes. And with proper guidance of an expert, you can plan, direct, and control how that happens for you. So how do you make that happen? How this works is I talked about having a strategy session. The first step in that is to just have a short phone call with our office to be sure we can help you. Right now, that intake person is Macy, and she would just go through some questions to get some information. After that, we'd have a 30 to 60-minute meeting in person. We also do Zoom or phone with me or one of the other attorneys. And at that time, we'll discuss your financial and your legal needs, review your current estate plan if you already have one to see what you have and see if it's sufficient or if it needs any updating, establish your long-term goals, and answer all the questions you have about your own unique situation. And at the end of our time together, you'll have an analysis of your current plan. You'll have better clarity of your issues and your goals. You'll have a blueprint on how to achieve those goals, an exact amount of the investment to achieve it. Then after the meeting, you'll decide how to get started. We'll draft a summary of your plan. We'll prepare the documents that are the framework of the plan, so you'll sign them at the next meeting. We'll meet with you again to sign the documents and begin the process of putting everything in place, like all those asset transfers and the funding that I talked about. Work together on the other steps if needed. And if you're dealing with a chronic illness or an aging issue that requires assistance, then we may get one of our care coordinators involved to see what's going on the health and the care side. The total value of this consultation is $650. However, because you have chosen to get on our workshop today, that is free. And so what's the catch? Is that we have limited spots available. And so if you want to book a free strategy session, you can call our office at the number there. There's also going to be a follow-up email because you registered for the workshop. And within that email, there is going to be a link that I'll show you that you can click on and to do a short survey and get signed up that way. My personal guarantee is that you'll know more than you did before today. You'll have an analysis of what happens if you do nothing, and you'll realize that there are options available to guide and protect you and your family, which is the most important, and your time will not be wasted. So again, if you want to schedule that strategy session, call the number or look for your email, and you're going to look for this link that looks like this. And in addition, if you sign up, you will get a book that Randy was a co-author on that's called What You Need to really need to know for the second half of life, which has a lot of more in-depth information about what we've covered today. And I think that's it. Thank you for listening. And Emily, I'll let you come back on and talk about what else we have going on.
Perfect. Just a few questions here, first of all, Jenny, and I would like to encourage everyone to go ahead and put any questions that they do have in the chat box before we kind of wrap up our presentation. So Jenny, could you please answer this question? When is the best time to plan?
That's a good question. We've kind of went through the planning options, but we didn't talk about the timing. So Randy made me get my powers of attorney and will in place before I had my first kid, which was probably good timing for that. So just getting the basics in place as soon as possible really is just having powers of attorney to have those people in place and having a will. But as you go, when you get to the age where maybe you're more interested in protecting property than using it, maybe you have a farm, maybe you have investments that you want earmarked for your kids. The big thing is we've got for Medicaid, there's a 5-year look back period on gifting. So if we want to set up an irrevocable trust, theoretically, we need to do it 5 years before anyone would need Medicaid. In reality, that starts to look like people in their 60s, 70s, even 80s, if they're healthy, to set up those trusts to protect property. Or if you're not worried about locking up your property, you just want to make sure you have a trust in place or a will, it's really never too early to do that, to get probate avoided. We just don't have a crystal ball to know how things are going to go. So I hope that helps.
Perfect. Yes, that was great. We have one more question here. What if we've already worked with an attorney in the past?
And that happens a lot. What we like to do is look at what you have and see if those documents, they may have been the right tool for you at that time in your life. Are they still the right tool for now? Do they have all those optional powers that we may need in the future? And sometimes the tax laws have changed. And so we'll just do a review of everything and give you our opinion on what you have and what may need to be updated.
Perfect. Thank you for covering that. We do have kind of a specific question